Welcome back to MLC Radio. I'm your host, J. Richard Jones, and I'm very pleased to be with you today. Today, we're going to venture over to the corporate side. We're going to talk a little bit about shareholder oppression. And our guest that's joining us today, when I asked him before the show, I said, what is the one thing that you'd like our readers and our listeners and viewers to understand about shareholder oppression? And he said, the overall principle of shareholder oppression is that the majority is controlling a minority. But is this always the case? And we're going to get into examining, really when we're talking about oppression, there are legal remedies, but is it worth pursuing? What are the pros and the cons? Joining me today is Mr. Malcom Burrows, and he is the legal practice director with Dundas Lawyers. Malcom, welcome to the show.
Good morning, John. How you going?
Not too bad. I thought that was a very interesting conversation because generally, it's the Davy and the Goliath scenario. The majority is controlling a minority, but it's not always that way, is it? Maybe you can tell us a little bit about what is shareholder oppression?
I suppose there's an interesting point from my perspective. You can look at it from two angles. One is that Section 232 of the Corporations Act, says that shareholder oppression can occur when the conduct of the company is either contrary to the interests of the members as a whole, or oppressive, unfairly prejudicial, or unfairly discriminatory to a member or members. Now that's to shareholders. But if you look at it from the perspective of the conduct, so that's the legal part of it. And sometimes people consider a shareholder oppression matter is a partnership dispute or a director's dispute or a dispute over remuneration or something like that. It might not necessarily appear to an individual as being an act of shareholder oppression. So, so when you look at that, if you look at things such as how is this control exerted by the majority? Now, it's also the interesting part. Majority isn't necessarily, you can have a 50-50 shareholder situation and have shareholder oppression. We've got one matter in court right now, which is just that, 50-50. But the control is exerted by things such as influence over an accountant, the way the structure has been set up, the way that one party has bank account access with another party and not the other. So there's, and skills is another big one, where one party has a certain set of skills that the other doesn't have, so they use that to the other party's detriment. So there's a lot of things that you will notice, and the big one also is exclusion from management, where if you've got several directors, which is not uncommon, they have directors' meetings without one of the people. And you look into it and you go, you know what, that's actually permitted. So there's certain things like that. And the other big one is access to information. So where one party is actually having their access to information restricted. And the good thing about that one is there's all sorts of legal remedies. You can actually apply to the court to get orders to say, give me the information, I'm entitled to it. So that's a bit of a long-winded explanation, but if you look at it from the conduct backwards, as opposed to the law backwards, it's inside out sort of thing. That I find that is the best way to do it. So what is the problem? And the problem might be that you're not getting the reports you keep asking for as a director, or somehow decisions are being made without your input. Those things can all be held to be oppressive, and they're all capable of legal remedies. It all depends, I suppose, on also the value of the business itself, the underlying company.
It's interesting because as you're explaining this, it sounds to me like there's a few common principles. I mean, one is the partner that you're getting into business with to begin with. The second thing is, I would imagine, good communication plays a role. And some of this is almost like a marriage. It's a relationship, right? So there is some give and take. And it sounds like when one person is unfairly leveraged, that's the point when there can be oppression. But I guess the other side of that coin is some of this is regular business practice. I mean, how much of this can be resolved, for example, with just good communication or perhaps third-party mediation before it becomes to the point that somebody wants to make a claim for oppression?
Mm. It's the old adage, a little bit of prevention is a lot, saves a lot of cure, and the cure is a lot more expensive. But most times a conversation can help that. Say, hey, I need to get these reports. But primarily, um, if somebody then objects to providing information or objects to allowing access to certain things, or you know or gets offended when somebody asks, it's almost like it's a trigger for, well, there's something really quite wrong. That's the way I look at it. An honest man is not offended by questions. So, about into the conduct of the business, where's the authentication for the bank account? Why are these all of the bank accounts? Well, go to the bank if you're a director and ask. Don't, if the other person gets offended, it's a sign there's a problem, I think. But that tends to be what happens, is that people will get offended and therefore they'll be pushed under the carpet. I mean, we've got a few matters that we have an ongoing relationship like this, that are ongoing, shareholder oppression matters, where one party is used to ruling the roost. There's two directors. We've got one that's the company's very old, it's like 50 years old, and has about $200 million of assets. And one director's just been ruling the roost. And as soon as the other director starts asking, well, I need to approve this or something, the other person gets offended, don't they? Well, why should you? You've never done it before. Well, it's sort of common sense, isn't it? If you're talking about, a lot of assets like that, why shouldn't the person be open to scrutiny? And it begs the question then, well, what is happening with these things and these transactions where they're paying their family and their best friend and, the local dog service provider out of company money? They should be pulled, held to account. So another long-winded way. I'm very passionate about this subject because it's the tip of the iceberg. What you see is the tip of the iceberg, and there'll be a whole lot of other stuff going on. And if you can have a conversation about it, I think an honest person will say, sure, have a look at this. Somebody who's got something to hide will make up 100 reasons as to why you shouldn't have access to it.
So it comes down to a certain degree. It's an issue of the integrity, and it's an issue of trust, and it's an issue of communication.
Exactly.
And in terms of motives, I think is it fair to say that it depends at the point of the life cycle of the company? And what I mean by that is, if you're a small startup, you're getting to know each other. There's personalities, there's growing pains. Versus if you're a mature company and there's a lot of money, partners are getting old, and maybe there's a new partner that's come on the scene or a director. Uh,
Mm.
how much of a factor is that in the whole process?
It's a big factor. It's probably not the life cycle, it's about the money. So you can have some startups who are very successful very quickly, and at some point in time, there will be a shift in what each director or shareholder thinks the other one is worth. And all of a sudden, I think, well, I don't need this other person. I'm just push them out the door. So then all of a sudden, there's that sort of ganging up approach, as a schoolboy would be, on somebody who they don't need anymore, or they perceive they don't need anymore. And if the contracts and things aren't done properly in the first place, that will leave that person in a world of pain and pushed out the door, removed as a director, and having no access to information in a company that may be growing. But it all comes back to money. Business is war, right? And if a company's making a lot of money and there's three directors and one thinks that, well, the other person is not pulling their weight, might get rid of them, push them out the door. So that's what it comes down to. It's about money, unfortunately.
How much of a difference does it make to have solid approach to the preparation before the shareholders even get involved in the company, or when a new shareholder or director comes on board? There's a policy, there's a shareholder agreement, there's a process in place. Is that kind of an ounce of prevention is worth a pound of cure
Oh,
thing?
absolutely, absolutely. And it's not just the preparation of doc contracts, which say, provide a positive obligation. And the classic that we put in any sort of shareholders agreement is that all of the directors and the shareholders should have complete access to the accounting system. So then there's no, you can't play the shell game with where the money is by moving it around because the person's got full access. But it is absolutely, prevention is worth an ounce of, it is so much more advantageous. And it's not just that; it's also then the practical implementation of that. Well, what about the bank account? Does the bank know that there is three directors, and do they actually recognise and communicate with all directors? So the other common sort of thing we see is whereby an accountant or a bank is liaising with only one director. That gives that director power. I mean, I saw one just yesterday where all of a sudden there was a significant amount of money which was owed to the ATO, the tax department. The other director had no idea about it because there was one public officer, but the ATO and the accountant were reporting to this one director. That one director chose not to let the other one know. So, you know, if you have some sort of inbuilt controls, not just in contracts, but the physical controls as well. So a bank account where two-factor authentication, someone initiates a payment request and the other person has to approve it. That's really what you need. That sort of thing.
So, it's funny because there's a process here and there's best practices in business and for the directors, which I'm
Mm,
sure you deal with this all the time. But, this trust factor keeps popping up. And I know I'm going to sound kind of dated here and flaky, but it reminds me of the book written by Stephen Covey in the 1990s called The Seven Habits of Highly Successful People, because they actually
yes.
had a corporate adaptation for that for companies to follow.
Oh,
And
didn't know that.
yeah, no, it's interesting because a lot of the things you're saying is about, seeking to understand, having the communication and the whole process in place. So I would imagine, from an HR point of view too, the stress on directors when they can't trust and they can't communicate has got to be pretty high, and then that leads to emotional conflict. Is that a safe bet?
Oh, absolutely. Absolutely. And then all of a sudden you see the symptoms of it, that they're not getting information, that they're not having their fair say, and may manifest themselves in arguments and all sorts of other things, which can be detrimental to the person who's being oppressed. You know, um, hmm.
Malcolm, I'd be curious because shareholder oppression, I think we're talking about oppression can be, as you've kind of alluded to, unfairly, uh, prejudicial, or it can be discriminatory, or it can be contrary to the interest of the directors as a whole. But
Mhm.
really, it's kind of about respect, isn't it?
Oh yes, yeah, and the amount of, I mean, I'm prone to exaggeration, so but I have seen lots of people who come in and talk to me about their problems they're having with a shareholder and a director, and they say words effective. I can't believe it. I was the best man at his wedding. Oh yeah, yeah, okay. Seen this before, because it's not necessarily. Whilst that's a good framework and a good start, and I've seen a number of very successful businesses with no contracts, no nothing, just purely trust. To me, trust has to be earned, and as soon as in that situation, most startups will start without a whole lot of spend on legal fees. They'll do the bare minimum, and then if you've got a good relationship, there's happy, down the track, and they will work through the details of a shareholders agreement, any sort of contracts, any sort of controls they want to put in place without a problem. It really comes back to that personality of the people if they're prepared to be open and transparent. And as much as I would, this isn't always generational, but that is a factor as well. So, generation of the people and the age and what they're expecting, as well as what you said, the life cycle of the company, where it's at.
Hmm.
Because if you're a listed public company, you've got all these controls, you have to have them because it's your listed public company. But where you're growing and you've become a significant business, you probably won't have those controls.
It's very interesting, and I would be curious. Like, there's a fine line between trying to work something out. It's a business. Suck it up, have the conversation, and be transparent.
Hmm.
I know I talked a little bit about mediation. Is business mediation, is there a success rate by having mediators come in before somebody goes and makes an oppression claim? How much of a role does that play?
That's an interesting point. And again, it's also about how much money the business is making. So if you're fighting over let's say the equity value of the business is $500,000. Really, there's just not a lot you can do, because a shareholder oppression matter might take 2 or 3 years and cost you $2 million,
Yeah.
or $1 million in legal fees. But therefore, it's a more complicated dynamic. But mediation can play a role in saying, well, this person isn't happy. Here's why. And to me, if there's a really valid reason, like they don't have access to the financials, you send them the accounts to sign every year. And I had one decades ago where it was a professional services firm. One director just signed the accounts. The other director had never seen the accounts for 10 years. Like, hello. And then the other director, who when asked to say, hey, can I look at this before you sign it, got offended. Well, shouldn't be offended, Um, but there's all sorts of the courts only hear, and you only see probably about, and I'm guessing because since this firm has been involved, we've been involved in 70 or so actual court matters, and of those, there's probably about almost 13 or 14 that landed as judgments. So you can work it out yourself. So a lot of them start, and then that percentage go to a judgment, and they're not all oppression matters, but one was partnership dispute. But it's the very large percent don't even hit court. People jump up and down, get a letter from their lawyer, and sometimes there is resolution because someone is reasonable and says, okay, well, I'll just give you access to the account system. Well, let's go to the bank and have two-factor authentication. But that gets back to what you were saying earlier about the quality of the person, or the actual trust, and how reasonable the person you are in business is in reality. I mean, whilst as a lawyer I wouldn't put much credence in knowing someone for a long time, because you don't know them in business, and money does strange things to people.
Mm-hmm.
It's like, when you're about to get an inheritance and you've got 2 or 3 siblings, all of a sudden, all sorts of weird things happen,
Absolutely. It's one of the biggest factors. One of the things you're touching upon here is the realities of making an oppression claim. One thing that's
Mm,
loud and clear is that it's costly, and it has to depend on what
mm,
the value of the business is, and there's judgment, there's
mm,
costs, there's stress. You see a lot of this
mm.
stuff. I kind of want to move to talking a little bit, and some of this you've covered already, but a little bit about the remedies and alternative solutions before you get to the point of that oppression claim. Maybe you could give a
Mm.
couple of practical points that somebody who's out there in a small business
Yeah.
or even a large business should consider.
Mhm. That's a good question. So the usual thing is the restrictions of information. So if you're a director, I liken it to showing my age here, but it's a backstage pass. It was the there was a movie where the guy had a backstage pass and he was flashing it all around. He could go anywhere, um, and it's very true that it's backstage pass. You've got a right to everything. So I had an unlisted public company years ago, and some of the directors walked in and started talking to people in the office. I'm going, "What are you doing?" Well, they're directors. Well, it's not preferable, and we had a discussion about that, but there's nothing wrong with that. They've got a right to everything. They can know whatever they want. And a director's role is really what they choose to drill into is up to them. But getting back to your question, because I can go off on a tangent for this, it's one of my favourite subjects. In the situation where you don't have access to information, for example, you don't have accounts access, or the other director is blocking you from the bank account or something silly, there is an absolute remedy which can be done by application to a court to say, give us the records. And anything that's commenced by application is a question of law, not a question of fact, although this can sometimes creep into it a question whether they do have access to certain things. And that's a fairly simple thing. And every one of those we've ever sent to the other side, as we call them, they always caved and handed over what the person is entitled to, because they have an absolute right to it. If you're a director of a company, not shareholders' rights are slightly different, but you can say, give us access to all the accounts, give us access to the records, I want all the contracts, whatever it is the director wants, they have a right to. And if they're being withheld, there's a fairly simple application to court to make them hand it over. That's a good one.
Yeah, that would be. I bet a lot of people are probably not aware of that either until they hire a professional like yourself.
Hmm,
Yeah.
absolutely.
Well,
So when you link it back to the conduct, what's happening, then you link it to the law. That's not that remedy isn't oppressive, but the fact that their information flow is being restricted is part of indicia of oppression. So there's a few things that can be done quickly, but again, the prevention would be to let's hard code that into a contract, which means instead of having to rely on the section of the Corporations Act, you can say you breached this section of the contract. It's sort of simpler.
so another, the pre-planning and pre-mapping saves a lot of headaches.
Absolutely, absolutely, yeah, absolutely.
This has been such an interesting conversation, Malcolm. Um, for our listeners and viewers, tell us a little bit more about Dundas Lawyers, your role, and the services that you provide.
Yeah, right. Um, we're based in Brisbane. I haven't always been a lawyer. I've been practicing for 15 years. And prior to that, my role was I was an entrepreneur and I had started internet businesses, and I think I was a victim of shareholder oppression. There was at one stage a company I was involved with, the directors resolved to sell the shares of the shareholders. Now, at that stage, I didn't have a friendly lawyer to say, can I actually do this? I did go and see a lawyer about something, a separate topic, and I got a bill for $2,000 for a meeting and a few other bits and pieces, and it was like, I can't afford this. But a simple call, any reasonable lawyer would know that the directors cannot resolve to sell the shares of the shareholders. So I didn't know my rights. And as a result of that, then I've had practical experience in, of actually being an oppressed shareholder. And, I think that is really telling because there's not too many lawyers in the country that can say that's happened to them. Perhaps it's happened to them as lawyers, but not as entrepreneurs.
You live
So if I had a friendly lawyer, yeah, that's right. So if I could have rung someone and said, can I do this? Any lawyer with their salt could have said, no, they can't resolve to do that. I just went along with it. Actually, I remember in my recollection was that I said, no, I don't want to do that. But that happened anyway, right? And I just thought I had to sign, but I didn't. And at the age I was at the time, that cost me a lot of money, life-changing amount of money. But that sort of spawned the practice of Dundas lawyers in this shareholder oppression issue. We also do a lot of intellectual property matters because that's sort of my basis as well. I was creating intellectual property, managing software teams, building, I suppose, innovation products. And now we do legal work for those sorts of businesses, growing businesses who, uh, from ranging from listed public companies to quite good growth companies who have some months a lot of need for legal support and or a project or something, and sometimes not much. It varies, but they're all not just in technology companies. We direct for a larger building company, a hotel chain, a couple of what we call large online verticals where they have a dominance in a market space, in an online market space. So that's sort of my background is online, but it's all changing now with AI and everything else. So the services really relate around my background prior to law.
I'd be curious to ask you in terms of AI and technology and as it pertains to corporate law, shareholder relationships and
Mhm.
agreements. How do you see that? Will it affect it in a positive way or a negative way, or is it neutral?
Um, Actually, it's interesting because I was actually on ABC Radio, Kat's show earlier in the week talking about this actual topic. There's AI in terms of copyright. That's the real guts of the issue is how they deal with this. And there's cases in the US whereby um, an AI has to ingest content or documentation to learn from it. And really, the question is that allowed? And there's 30 cases in the US ongoing about this against big companies. But how it's going to change, I think, the business landscape is that I'm seeing more and more people say, I asked AI this and it said that. And these are existing clients. And sometimes another client say they spent all day doing the research. They come up with all these points. And they sort of applied, sort of, but not really.
Hmm.
So I think AI is going to change the landscape of things. It certainly makes certain tasks simpler, and if you can train things in a certain way and create tools for short circuiting things, production of affidavits, cataloging of documents, all of those sorts of things, I think that's going to have a big change, an impact on things. I have seen a couple of people who have said, "Oh, my lawyer's done this document," and they're the other side, as we call them, and they've sent it through to my client. And you look at it and you go, "No, his lawyer didn't do this,"
You can tell.
because you can just tell straight away. So I think AI is going to change the nature of everything, but there can be, in the context of shareholder relationships, well, maybe it could be used in a positive way, whereby you set up an AI agent to go and gather information and produce reports.
Yeah, that's
That's a great idea.
automation. Yeah.
Yeah, yeah, absolutely. So I think there's going to be some tools that come up like that, which will make life easier, and then allow a director's uh, role to be more strategic and more, helicopter level, but also allow them to drill into information when they want to. So I think there'll be a change. Whether or not how positive, I'm not sure yet.
Well, time will tell. I mean, I'd love to in another podcast stream with you talk about intellectual
Mm,
properties. I hope you'll come back. The other thing
yeah,
I'm
sure.
hearing a lot here from where we are is the standards that are going to be in place for dealing with AI, especially when it comes to content. And
Yes,
I hear a lot
yes.
about this idea where people are actually, for lack of a better word, they're developing like an ISO standard to be accountable for and for your policies. That's an interesting topic. I'll have to have you come
Mm,
back and chat about that. I've been listening to My Legal Crunch Radio, and we've been talking about shareholder oppression with our special guest, Mr. Malcom Burrows, who's a legal practice director with Dundas Lawyers. But I feel like we've covered so much. I mean, so much more. We're talking about business principles for running your business. We're talking about communications. We're talking about the challenges, costs, and the realities of shareholder oppression as well that you have to consider. It's been wonderful to have you on the show, Malcolm. I hope you'll come back
mm.
again as well.
Thanks very much for having me, John.
Thank you.